Okay, so Mr. Semke, I did confirm that, yes, the complaining witness or the prosecuting attorney was notified. And then is this the complaining witness that's in the courtroom now?
No, that's her attorney. Or at least, I believe so.
Okay.
Good morning, Your Honor.
Okay. Can you turn? Oh, there you are. Okay, thank you. Okay. All right. So we are going on the record in the matter of the state of Michigan versus Shadid Howard Randolph 23302. And appearance for the people, please.
Good morning, Your Honor. Please, people P 214.
Thank you. And counsel?
Good morning, Your Honor. Mr. Shanky, on behalf of my client who stands to my immediate right.
Thank you. And Mr. Howard Randolph, your name, please.
Shadid Howard Randolph.
Okay, so before we go any further, I'm going to make this statement. And I'm going to indicate the last time you were here in court, sir, which was April 20th, there was significant disruption to the court.
Right off the bat, notice how the court is clarifying who's actually present. This is crucial. A victim not showing up doesn't mean the case disappears, just shifts the strategy. And already we're seeing how Randolph's behavior might come under the microscope.
This. If there is one interruption by you with anybody that's talking on the record, whether it be the prosecutor, your attorney, any witness testimony, or the court, you will be held in contempt of court. I just want to make sure you understand that. Do you understand that?
Can you repeat it again? Did I do something wrong? You said I did something wrong.
What I indicated is the last time you were here in court on April 20th, there was a lot of interruptions. We had a disastrous record.
Stop.
We had a disastrous record. So what I'm indicating, so I can make sure that we have a clear record and that I am maintaining order in the courtroom, that there will not be any interruptions by you, whether when the prosecutor is talking, your attorney is talking, any other witness, or myself. If there are any interruptions by you, Mr. Howard Randolph, this court is going to hold you in contempt.
And this is where you should lean in when a judge gives such a strict warning before things even start. It's like a teacher saying one more word and you're out. That's a sign the defendant has already crossed lines before.
That I will be speaking for him today, pretty much for the majority of this, for this proceeding. So I don't believe that's going to be an issue. But thank you, and we're well noticed that everyone has to wait their turn to speak. Thank you for the notification. No, you cannot. You just were told no interruptions. Just stand there quietly. I will do all the talking. Just interrupted me, and that's something you said you were going to do. I'll do it. We're ready to proceed, Your Honor.
Okay, Ms. Ozier, would you like to address the court? If you can step forward, please.
Yes, Your Honor. I am representing Ms. Duff in the custody matter, and with regard to Mr. Howard Randolph potentially being in custody, that was something that we did inform the judge of yesterday, and he said that he would accommodate as necessary if that is the case. I plan to appear as soon as I am back to my computer to inform the judge of the way that these proceedings conclude. I would also like the court to note that while it's been made clear to Mr. Howard Randolph that there is no contact electronically or by other means, that throughout the trial proceedings, Mr. Howard Randolph has continually directly addressed Ms. Duff during these proceedings, which would violate the no contact. And I believe that that will continue to happen. The Randolph today might be great, but throughout the Zoom trial has not been great, and he has made threats and has spoken in threatening ways to myself as well as Ms. Duff.
Did you catch that? A disastrous record. That's courtroom code for chaos, transcripts full of interruptions, arguments, maybe even outbursts. And here's a question for you. If you were on the jury or watching this unfold, would you trust a defendant who can't even sit still in front of the judge?
Inclined to reduce further. I would only ask for this one allowance that my client just financed a vehicle. It's in the parking lot. Is no one else to get the vehicle. He asked if I'd be willing to drive to his address. I indicated that it doesn't fall within the things that I'd be willing to do. I asked that my client get a report, if not tomorrow, so we could just take the car back, because not only is he going to be missing the hearing, he's going to be going into custody. I don't want him to be in a position where his car gets towed and he's going further and further down an avenue that we're just trying to halt and put back into an advantageous position. He understands that if he fails to appear, the consequences are going to be it's going to be a catastrophe. So that would be the only allowance if there'd be no bending on any further bond conditions that he be able to.
Okay, and I can appreciate that, counsel, but Mr. Randolph can leave his key at the window with the police department, and we can make sure that they're not having it towed, and then his girlfriend can come pick up the key later with the vehicle. I'm not giving him a report date, not at all. I have serious concerns for safety and compliance with this court order. So court 10%, no surety, GPS tether in the event bond is posted. You can leave your key with the police department, and then we'll make a note that with what your vehicle is so that it's not towed and that somebody.
This is the turning point. Threats and no contact violations are not minor slip-ups. They show a pattern of intimidation. And courts hate that. Quick insight. Even if you're innocent of the main charge, breaking bond conditions can land you right back in jail instantly.
That's up to your attorney.
Well, that's up to me. I got my own mouthpiece. You don't already do what you're gonna do, bro.
Sir,
Okay.
let me just be very clear.
Mhm.
Your attorney would advise you whether or not you should or should not address the court based upon what it is you want to say or not.
Because in your commission,
you're interrupting me.
Okay, go ahead.
Notice the defense strategy here. Humanize the defendant. They're not arguing innocence. They're asking for practical allowances, like saving his car from a tow. But the judge shuts it down, showing that safety outweighs convenience every single time.
Something you say could be used against you.
Mm-hmm.
So that is why I indicated if your attorney suggests that you speak.
Need to hear about this.
Okay, now I'm holding you in contempt. I've already indicated that you are not to interrupt this court, yet you continue to do so. I've given you one chance. I've given you one chance right now. The court is going to indicate pursuant to MCL 600.1701 that you are engaging in disorderly, contemptuous, insolent behavior during the immediate view of this court and in the court's presence, directly intending to interrupt its proceedings and impair the respect due to its authority. Further, that under MCL 600.1701B, that this court finds you are in contempt during any breach of the peace, noise, or disturbance directly tending to interrupt this court's proceedings. The court will also indicate that this has occurred in the presence of the court. Therefore, the court may punish you summarily by fine or imprisonment or both.
And there it is, Randolph, accusing the system itself of corruption. This isn't defense, this is defiance. Here's a thought for you. Does calling the judge corrupt make him look brave or desperate? Drop your answer in the comments.
Therefore, the court's going to indicate 15 days jail for contempt. The court's going to also indicate that while, sir, you were quiet and not interrupting this court's order, nor the proceedings, towards the end of the proceedings, then you began to interrupt this court. Despite this court's order not to.
Not to speak my mind?
Not to interrupt this court.
I didn't interrupt.
Therefore, as is evidenced still by your continued interruption of these proceedings, the only corrective action necessary to restore order and maintain the dignity and authority of the court is to hold you in criminal.
False police report, you let it get in your courtroom. So did the prosecutor and the tenure.
Sir,
commission will hear about it, and it's already, you got a grievance on you already right now.
Sir, you may file anything that you
June the
choose.
1st, hey, listen,
You
this
may
domestic violence.
Stop interrupting.
You're gonna.
Stop interrupting.
Guarantee that.
Okay, well, at least you're helping the court make a record for yourself, for the court as well, as to why this court found you in criminal contempt. You're not to address,
Okay, I'm addressing the bar though.
sir, the court's adding your next 10-day hearing for you addressing the victim in this matter. So a total of 25 days. Off the record.